All right, this is in the matter of the people of the state of Michigan versus Jamie Lee Carden, file number 2022-21124 FC. I have David Goldstein appearing on behalf of Jamie Carden. I have Jacqueline Weiss appearing on behalf of the people. Is Mr. Hartung also here on this? And Douglas Hartung appearing on behalf of the date and time set for a plea in this matter. I have received an amended information. Mr. Goldstein, have you received that amended information?
Yes, Your Honor.
All right, and how would you like to proceed?
Before we begin, Your Honor, I'd like to ask my client some questions.
Okay, so Ms. Carden, yep, go stand there and I'm going to ask you to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, let's step by the microphone with Mr. Goldstein.
Ms. Carden, did we have more than one conversation prior to today about pleading in these matters?
Yes.
And during those conversations, did I explain to you there were different offers made, and then did I explain to you the latest offer?
Yes.
That included an offer from the people with regard to what the charges would be, and an offer that included what we call a Cobb's agreement with the court regarding your sentence.
Yes.
And did you believe during those conversations that you understood what the offer was?
Yes.
And did you at some point during that the last conversation indicate that you wanted to accept? You did, however, say that part of the reason you wanted to accept was that you didn't have, prior to that discussion, did I indicate to you that the decision was strictly yours as to whether you took but did I tell you that since I was not being paid, I could not properly mount a good defense for you and would not continue with your attorney if you went to trial? And did I tell you, however, that if you wanted to go to trial, but I didn't want you to decide on that basis, that if you wanted to go to trial, the court would provide you with counsel at no cost to you?
Yes.
Okay. And even after having been that explained to you, did you still indicate to me that you wanted to take the deal?
Yes.
Okay. Has anybody forced you to take the deal?
No.
Has anybody threatened you to take the deal?
No.
Okay. Do you want to proceed and take the deal today?
Could you place the agreement on the record then?
Your Honor, my client will tender a plea of no contest to count 1 and to the amended or added count 3 in the one file, the file that ends in FC, and to count 4, which is fleeing and eluding, in the other file. The agreement with the people is that all the sentences that the court imposes would be concurrential for stacking them, but we've agreed that would be concurrent. And the court, after discussing the matter with counsel for both parties, indicated that as a Cobb's agreement.
This is the quiet part most viewers miss. The court is making absolutely sure this isn't a pressured plea. No threats, no promises outside the record. You can hear how carefully the lawyer frames it. It's your choice. Counsel would be appointed if you want a trial. That matters later when the sentence lands. The record will show she owned this decision.
All right, so Ms. Carden, I've already sworn you in. So you've heard the statement of your attorney and the prosecuting attorney. Is it your intention on file number 22-21124 FC to plead no contest to count 1, child abuse first degree, which carries a maximum penalty of up to life or any term of years, but there was a Cobb's agreement that your minimum sentence would be no more than 12.5 years. Is that correct?
Yes, Your Honor.
Okay, and it's your intention to plead no contest to that count? Okay, so you're kind of soft-spoken.
Sorry.
Yep, no, it's fine. And Mr. Goldstein, you can move the microphone a little bit lower for her because, yeah, and then I need you to speak up so we get a good record, okay? Then on that same file, is it your intention to plead no contest on count 3, assault with intent to do great bodily harm less than murder or by strangulation, which carries a maximum penalty of up to 10 years in prison?
Yes, Your Honor.
Okay. And then on file number 22-20792 FH, is it your intention to plead no contest on count 4, police officer fleeing 4th degree, which carries a maximum penalty of up to 2 years in prison and or a $2,000 fine, along with a license suspension not to exceed 5 years? So is it your intention to plead no contest?
Yes, Your Honor.
All right. Now, your attorney thoroughly asked you about this plea, so you've had ample opportunity to speak with him.
Yes, Your Honor.
And you understand if you didn't want to enter a plea and you wanted to continue to trial, the court would appoint counsel to represent you.
Yes, Your Honor.
But you wish to continue with the plea.
Yes, Your Honor.
And you are satisfied with Mr. Goldstein as your attorney and the advice that he's given you.
Yes, Your Honor.
Okay. So other than the plea agreement and the Cobb's agreement regarding count 1 of file number 22-211-21124 FC, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Goldstein?
That's correct, Your Honor.
Mr. Hartung?
That's correct, Your Honor.
Ms. Weiss?
That's correct.
Okay. And that correct as far as you're aware, Ms. Carden? If a guilty or if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. And that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial. Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that? If you are not a citizen of the United States of America, a conviction of a crime may result in deportation.
Rights are everything a jury trial gives you. Presumption of innocence, cross-examination, the state's burden beyond a reasonable doubt. When she says yes to giving that up, she's trading the uncertainty of trial for the certainty of a negotiated floor. It's heavy because victims and the public want answers. But the law also demands a clean, informed waiver.
To be a change to the information. When it was retyped, they put January 1st, 2016. The original information contained a time period starting January 1st of 2016 and ending June 5th of 2019. Ms. Weiss is going to move to amend.
Ms. Weiss, you'll amend that?
I do a move to amend that, Your Honor.
Okay, and you'll get a copy of that to us today.
Yes, Your Honor.
Okay. All right. So, Ms. Carden, how do you wish to plead to the charge that during the time period of January 1 of 2016 through June 5th of 2019 in the city of Morenci and the county of Lenawee, that you did commit the offense of child abuse first degree? And on that same file, during the time period of January 1 of 2016 through June 5 of 2019, in the city of Morenci and the county of Lenawee, how do you wish to plead to the charge that you did commit the crime of assault with intent to do great bodily harm less than murder or by strangulation?
Okay.
All right. Has anyone made any threats or promises to you to induce you to plead no contest to any of these charges other than what was placed on the record? Do you understand that if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter? Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Goldstein?
No, Your Honor.
Mr. Hartung?
I should probably place on the record that it was alluded to in Mr. Goldstein's reading to Ms. Carden earlier, but this will be a non-consecutive sentence. You did not outline that during your reading of the rights. The other thing we probably should put on the record is the basis for the contest.
It would be for civil liability, obviously.
Okay, so civil liability and it's non-consecutive,
That's correct.
so it'd be a concurrent sentence?
That's correct.
Okay. Do you know what that means? All right, Mr. Goldstein.
No, okay. You had two different files, okay? There is a potential that you could get a sentence on one, and then after you did that sentence, you would start your second sentence. That's called consecutive. But the prosecutor has agreed that if you receive a sentence on all of these charges, they're all going to run at the same time. Okay.
Do you understand?
Yes, Your Honor.
Okay. So Ms. Weiss?
Your Honor,
Well, I think I was bouncing around, so I said, is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? He added that. Has your attorney, I know that there's a Cobb's agreement to no more than 12 and a half years in prison on the one count, but other than that, has your attorney promised you any particular sentence or estimated what your sentence will be? Is it your own choice to plead no contest? All right, who will be placing the factual basis on the record?
Your Honor, I will, but I believe Mr. Goldstein and I would stipulate to using the preliminary exam transcript as well as the trauma assessment report that I will get to the court. However, I have summed it up for the court to make its findings for today.
And can you please use initials?
Yes, absolutely.
Thank you.
I would indicate before she does that, she and I did meet prior to court today, and I've agreed on that because we'll take the court. This is not one of the kind of cases where you can go to one paragraph and find the elements of the crime, so.
One last thing would be that the court indicated in this card that the sentence would not exceed 12 and a half years. 12 and a half years on the minimum.
On the minimum, I did say that earlier. So you understand there's a minimum and a tail. So any term of years, but your minimum sentence would be 12 and a half years.
Here's the headline. Child abuse first degree carries up to life, but the judge agrees not to exceed a 12. 5-year minimum on the top count under a Cobb's cap. Cap isn't mercy, it's structure. It acknowledges seriousness while avoiding the chaos of trial. Also note, concurrent time, not stacked. That single word changes everything about how long she'll actually serve.
Just say at that time she was.
At the time of January 2016 through June 2019, for the date of the information, all these children were minor children.
Under the age
I would
of,
agree with that, Your Honor.
Correct.
under the age of 17?
Yes.
Yes.
Okay.
Yes. We have TIC, DEC, TRC, DAC, TEC, and DAMC. And to clarify, some of these incidents happened outside of the city of Morenci, although some did happen. So for the purposes of this, we would just indicate that between January 1st, 2016 and June 5th, 2019 in Lenawee County, Michigan, all these instances occurred. Based on testimony from both Chris Carden and Muriel Polaskinski, beginning in 2013, Chris and at least 3 different CPS workers discussed with Jamie that Sam Compton was a convicted sex offender and not to have her children around him. Jamie abused pills, cocaine, and methamphetamine. During that time frame, Jamie had care and custody over her children. Beginning in January of 2016, Jamie would regularly drop off her children to Sam Compton. TC, that Sam would take her to his bedroom, take his clothes off, take her clothes off, rub her on her inner thigh, both inside and outside her vagina. Sam did this to her multiple times. TC told Jamie Sam was doing this to her, and Jamie didn't listen or believe TC. Every time Sam would watch the children, Sam would pay Jamie. After TC told Jamie Sam was doing this, Jamie continued to drop the children off to Sam. TC testified that Ernie Black was one of Jamie's friends that would frequent the
Could you
house.
slow down your reading? And so when you read really fast. I'm trying to take notes.
I'm
What
sorry,
was the next? Ernie Black?
Ernie Black. TC testified that Ernie Black was one of Jamie's friends that would frequent the house in Morenci. The first time TC met Ernie, TC was 5 or 6 years old. Ernie showed TC and DAC a video of naked people on a bed doing stuff to each other. Ernie told the girls that if they did that with him, he would give them candy. The girls declined his offer. Ernie first went to DC's top bunk and DC left the room. Ernie then went to TC on the bottom bunk of their beds and was rubbing on her like Sam would on her thighs and vagina. TC told Jamie about it. Ernie came over again after TC told Jamie. This time TC was in the living room. Ernie undressed himself and TC. He got on TC and was rubbing his penis in between her thighs. TC testified that his penis went inside the lips of her vagina, but not all the way inside of her. TC told Jamie about this incident. Jamie did not believe her. Jamie continued to allow Ernie to come to the home.
Not replaying graphic detail. What matters is the pattern, CPS warnings, knowledge of danger, and continued decision to expose children to known offenders in exchange for favors and cash. That's why child abuse first degree fits. It's not just failure. It's knowing facilitation of harm. For edit, keep the institutional facts, blur/mute sexual specifics, overlay the CPS timeline and prior warnings, lower thirds.
The court finds beyond a reasonable doubt that during the time period of January 1 of 2016 through June 5 of 2019 in the city of Morenci and the county of Lenawee, that the defendant did commit the offense of child abuse first degree by knowingly and intentionally allowing serious physical and mental harm to a child and causing it by allowing two registered sex offenders, Ernie Black and Samuel Compton, to babysit unsupervised the minor children, all under the age of 17. Approached their mother and report that the abuse was happening, and the mother failed to remove the children from the situation or report it. In exchange for him being allowed to babysit her children, she received a vehicle as well as cash. I think that satisfies child abuse first degree. On the count 3, assault with intent to do great bodily harm, less than murder or strangulation, and received multiple reports that her children, especially specifically TC.
This is the court's moral line in legal form. The judge ties it together. Reports from the children failure to protect the medical PTSD findings. Findings like these matter for appellate record and for the victims. It's an official acknowledgement of harm, not just a number of years. Justice isn't tidy here. A controlled sentence, a capped minimum, and a record that finally says, we see what happened. If you're a mandated reporter or a neighbor who looked away, this is the reminder. Silence is a decision,